All right, we are back on the record in the Allen case, 24 CR 42183 and 25 CR 42926. Anything, well, first of all, any reason that we should not go forward with sentencing?
Right here is the calm before the storm. The judge is checking whether anything legally blocks sentencing today. And once both sides say no, this train is leaving the station. From this moment on, the focus shifts from what happened to what punishment fits.
It's today.
No, Your Honor. No, Your
All
Honor.
right. Mr. Harris, on behalf of the state.
Your Honor, Mr. Allen has 214 days of jail time credit that should be applied, I believe, to the 2024 case. Your Honor, the defendant was granted opportunities beyond community control initially in his case in 2024. He violated that soon thereafter. The court granted him another opportunity to be out in the community under electronic monitor. That lasted for a period of 2 days. Under the circumstances, I think the defendant's proven he's not amenable to community control.
This is a critical legal turning point. The prosecutor is laying out a pattern. Multiple chances, multiple failures. In sentencing, that phrase, not amenable to community control, is basically code for probation has officially run out of road.
And we would ask to impose a prison sentence. As far as restitution is concerned, a couple of the pieces of equipment were turned in today. So restitution would be $2,099. That's just for the monitor that was not recovered. And I think that's the only deviance from, that was our last state's Exhibit 8, which was requesting more than that. But Officer Wilson came down and plugged up the equipment. It does work. So we are taking that off as far as the restitution request.
So I'm looking at Exhibit 8. We have the charger and the recharger both were returned. So we have the restitution being $2,099.
Correct.
Okay. Officer Conroy, anything from Community Corrections?
Yeah, Your Honor.
Mr. Fisher?
Nothing further, Your Honor.
Mr. Elter?
Your Honor, I've been speaking with Mr. Allen throughout the process of this case. What led to the ankle monitor being removed was he had a drug habit. And that's actually what happened this exact day when this monitor came off. Was he was with friends, he took it off to use, knew it was a bad idea, was caught a couple days later. His issues have been substance abuse. I think you'll note his record, while he does have a record, it's largely non-violent. It really is what I call self-destructive crimes. He's been very remorseful and very respectful and engaged in his defense in this matter. I think he's a very thoughtful person. And I think the 214 days that he's been in jail have allowed him to regain his sobriety.
This is a strong emotional appeal from the defense. They're not denying the violation. They're reframing it. The argument is, addiction isn't defiance, it's disease. But the real question is whether the court sees treatment as accountability or as another risk.
The clarity of his thought, the degree to which he participated in his defense. As the time has gone on, I can see him. I can see the lights switching on, if you will. So what we're asking, Your Honor, is to consider a CBCF program for him, some sort of program where he can go get residential treatment, get himself squared, continue on so that when he gets out, he can get a job. He can progress further as he wants to. He's actually being very sincere and caught up in emotion in terms of the circumstances, and he's had the support of his family, who I think would vouch that if he were given the opportunity, they would support him and be his support community. And I would also offer, if he were sent to CBCF, he stay in contact with me, just so that he's got somebody to talk to. So, Your Honor, he's always considered the ramifications of this charge. He thought that it was necessary to take it to trial because of the question regarding the notion of detention. So he's here taking full accountability. He's remorseful. We'd ask, Your Honor, to give him a chance to hang on to the sobriety that he's achieved during these 214 days and to move forward.
Mr. Allen, what do you want to tell me?
Yes, in regards to what you said, it's true. I've been finding myself to make my situations worse than what they are. put myself in hazardous situations. And I've been in jail in maximum security for 4 months now. And I've thought about a lot of things. Also, I've been in the law book, obviously. I solely thought that I was not guilty of this crime. And that's the only reason why I took the proceeding the way that I did.
So I don't want to interrupt you, Mr. Allen, but I want to make sure that you understand this clearly. I don't punish people for going to trial. So the fact that we had a trial
This moment matters more than people realize. Judges say this to protect a constitutional right, the right to trial. If courts punish defendants for exercising it, the entire justice system would collapse into forced plea deals.
morning, there were some questions as to whether or not this specific set of facts fits this specific charge and all that. I don't consider that at all either, for or against you. The fact that we had a trial this morning, I don't hold that against you. So, I don't want to interrupt you, but you don't have to spend a lot of time on that. The fact that we had a trial this morning is not being counted against you. Go ahead.
Like I said, put myself in high-risk situations. I have to change my lifestyle. My lifestyle has played a major part of all the things that's been going on in my life. I've been to prison 6 times. It seems like every time that I go, that I lose a part of it. But I do take full responsibility for everything that I have done. But what I haven't done is take care of the real problem, and that's my drug issue. I really need to take care of that. And that's all I need to say.
So here's where we're at, Mr. Allen. I get what you're saying about drug problem, being to prison before. We put you on probation, gave you some rules to live by, and it didn't really go that well. So I think it seems like Mr. Allen doesn't want you to speak, ma'am. But who is this?
That's my mother.
That's okay. That's okay. All right. Well, let's do this. Mr. Elter, why don't you and Mr. Allen have a seat at council table? Ma'am, why don't you step up to the podium for me? Tell me your name and what it is that you want me to know about this.
Tracy.
Okay?
If I may say, he's not telling a story when he says he has a real bad issue with drugs. And it seemed like, bad as I want him to come home, I don't. Because I'm afraid he'll do good and then he back out there. And I remember calling his probation officer, whoever it was that was on the case, and I said, do you really think he need to come home with a monitor? I said, because he needs to be in a program, a long-term program. And he think it's hard. I've watched every stage. Every stage. I told his lawyer that. Every stage. And I'm his mom. I love him and I support him. But he really does need help. And when you go to jail and you get out, it's supposed to be reformed, but yet they let them out and they're on their own. And then when you get to asking people, it's easy to say, I've never been on drugs. I just know people have. And they'll say, well, you gotta want it, you do, but you gotta keep getting that help that you need. And they'll say, well, we can't help him. We're just here to do this, and he's on probation, and that's it. Now, if he wants help, he can go here and there. It's easy said than done, but I haven't been on it, but I've watched the struggle. I really have. He's not a bad person. He's really not. It's just, it has a hold on him. It really does. That's how
When a judge hears from a parent like this, it hits different. She's not asking for mercy. She's asking for structure. Ironically, That can sometimes justify a harsher sentence because the court now sees treatment as necessary, not optional.
Okay, thank you, ma'am.
All right.
So again, Mr. Allen, I get what you're saying. I don't disagree with Mom at all. First of all, just because you're convicted of numerous felony offenses and numerous doesn't make you a bad person. We don't convict people of being bad people. That's not how this goes. You're convicted of a specific crime. The problem that I have is I just can't send you straight to a program based upon your criminal offense, because then I have everybody who I let loose on a monitor is going to cut them off and make a run for it. There's a punishment that is required in this case. Punishment has to be serious, because I have to know that people that I put on these monitors are going to obey the terms of them being on the monitor. So what I'm going to do is, I am in the 24 case, I'm going to impose 214 days in jail. I'm going to credit you the 214 days that you have already done. I'm going to shut that part of the case down. In the new case, I'm going to sentence you to 24 months in prison. And you have no jail time credit on that. I'm also going to sentence you to 12 months in prison on the theft charge. I'm going to order that those be served concurrently. That means at the same time as one another. And after a year in prison, if you behave yourself, I will favorably consider you for judicial release into what we call a community-based corrections facility, someplace like STAR or CCC. So I'm willing to break this case into two parts, a punishment part and a treatment part.
This is what balanced sentencing looks like. The judge isn't choosing between prison or rehab. He's sequencing them. First consequence, then opportunity. And that 1 year mark, that's the fork in the road where Mr. Allen decides who he's going to be.
You have to do your part during the punishment part, stay out of trouble while you're in the institution, do what you can. If you do, then after a year, I will give you the opportunity to go into a program. What a lot of people say to me, though, Mr. Allen, is they do the math on that and be like, I'd just rather serve my time out and not go to the program. That's also fine with me. It doesn't matter to me on that part. But if you do that, that sort of suggests to me that maybe you're not as serious about the treatment as you say, and you're just sort of looking to get out as soon as possible. Because Mom is right. Just opening the prison doors and expecting you to be different is probably not going to happen without an intervention. But you need to cooperate with that. And when I give you rules to be on a monitor, that kind of stuff, and you cut those off, there has to be a consequence to that. I'm not going to impose a fine. I am going to impose restitution in the amount of $2,099. This 24-month sentence also includes an mandatory period of post-release control. That means if you serve your entire sentence, the adult parole authority can or will supervise you anywhere from 1 to 3 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. It's automatically consecutive to the sentence that you would receive for the new felony. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, those will all be provided to you without charge. Whether or not you appeal the case, Mr. Allen, has no effect on whether or not I judicially release you. So if you want to exercise your right to appeal, that's fine with me. I don't take that into account when I am determining whether or not I should place you on judicial release. Really, the only reason that I am considering releasing you back into the community on judicial release is because you have people behind you that care about you. And most of the time when we do these cases, Mr. Allen, it's just me, the defendant, and the lawyers. Nobody has anybody that cares about them enough even to show up, let alone to speak up. So however this comes out when you're done, you need to lean into those people who are behind you because they want you to succeed far more than I do. All right, anything else? Anything I forgot?
There you are.
All right, good luck to you, Mr. Allen. You do have 30 days from the filing of the judgment entry of sentence to appeal as a matter of right. I anticipate that that's going to be today. If you want to file a notice of appeal, let Mr. Elter know that. He will appeal the case for you, but he will not be your lawyer for the purposes of